Good morning, good afternoon, good evening, IMT. Welcome to the quarterfinal or semifinals rather. My name is Janito Simon. I am a coach, an attorney. Specifically, I coach Fort Lauderdale High School. I coach Florida State undergrad, as well as Florida State Law School in mock trial. I've been a practicing attorney for about 13 years now, specifically focusing on serious criminal defense cases. I look forward to this round. Good luck to both teams. And now we'll have our another one of our judges, Mr. Jordan Katz, introduce himself.
Hi, everyone. My name is Jordan Katz. I am currently a junior competitor on Vanderbilt University's mock trial team. I've judged a lot for IMT, and I competed in Georgia high school mock trial for all 4 years. So I've been in your shoes before, and I'm looking forward to a really great round.
And now we have Judge Latha representing herself or introducing herself.
You. Hi, everyone. My name is Latha Srinivasan. I am an attorney. I've been an attorney for over 25 years here in Ohio in the USA. I am a former mock trial competitor both at the college and law school levels, and I am a mock trial coach. I started and coached a middle school mock trial team for 13 years, and I am now coaching a high school team in Ohio that is not involved in this competition. Um, my area of law is labor and employment law. I litigated for 15 years before I pivoted to HR compliance, and I continue to be involved in mock trial as a judge. I judge college and law school mock trial tournaments and have been for about 20 years. Good luck to everyone today. Really looking forward to this. Congratulations on making it to this level. We look forward to judging this level and seeing all your talent. So good luck and thank you.
Okay, and with that, we'll get started. Plaintiff, are you ready?
Yes, Your Honor.
Defense, are you ready?
Yes, Your Honor.
Okay, can I get appearances, please? Plaintiff first.
Yes, Your Honor. Before we start, could we inquire what time zone you're in?
It is approximately 9 a.m. in my time of the world.
All right. In that case, good morning, Your Honor. My name is Emma Suen, and along with my co-counsel, Katelyn Choi.
Good morning, Your Honor.
Good
Oh,
morning.
do you
We are
see me?
present.
Am I visible?
Not on my laptop.
I'm so. Oh, how about now? Wait. Oh, let me.
Apologies. I think my co-counsel is still having technical difficulties.
Well, that's fine.
So we represent the plaintiff in today's case, the estate of the deceased Arthur Henley.
Okay, can I get appearances, please, defense?
Yes, Your Honor. Good morning, Your Honor. My name is Tobin Hill, and today I am joined by my co-counsel, Miss Anya Luo,
Good morning, Your Honor.
and together we represent the defense on behalf of Dr. Elias Hornby.
Okay,
Good
understood.
morning, Your Honor.
Good morning, doctor. Okay, with that, do we have any housekeeping matters, plaintiff, you'd like to address? Attorney Choi, have you been able to figure out the tech issue?
Uh, Unfortunately, not yet. But we do have a few housekeeping matters in the meantime.
Okay, proceed.
We'd like to invoke Rule 603 and 615, the constructive sequestration and swearing of all witnesses bearing party representatives. And our party representative will be Miss Andy Parr.
Understood. And I assume for the defense, the party herself will be present, Dr. Hornsby?
Yes.
Okay. Anything further, plaintiff?
Yes, we'd also like to ask for preferences on screen sharing. Would you prefer that we ask for permission each time, or we just simply state it for the record?
Just state it for the record, please.
All right, and finally, we'd like to bring the court's attention to stipulation 13. As you can see from my screen here, Andy Parr is the duly appointed and legally recognized executor of Arthur Henley's will and estate.
I understand.
And with that, plaintiff is ready to proceed.
All right. Anything defense, housekeeping wise?
Yes, Your Honor. We'd like to ask your preferences on striking from the record. Should we ask for it to be stricken, or should we assume that it has been?
You all get paid the big bucks. I can't do your job for you, so I would ask if I were you.
Yes. And finally, we'd like to invite the court's attention to case law Minerva v. Rickman. It states that in wrongful death cases, a physician or medical practitioner is not required to guarantee a successful outcome for a patient, nor is an error in judgment automatically considered a breach in the standard of care.
Heard. Understood. Anything further?
No, Your Honor. With that, we're ready to move on.
Okay. Plaintiff, would it be Miss Attorney Suen or Attorney Chow who's doing the opening?
It's Attorney Choi, and she's still having technical difficulties. We're trying to get her to join another device right now.
Okay. We'll take some
Really
time
sorry
and allow
about
her
this.
to.
All right, thank you, Your Honor.
Plaintiff, are you ready with opening?
Yes, Your Honor.
All right, you may begin.
Your Honor, members of the jury, opposing counsel, may it please the court. Her negligence injected the wrong drug. It was a fateful day, February 16th, 2025, at Langford Hospital, when Elias Hornby, the defendant, was treating her own uncle, Arthur Henley, for anxiety and high blood pressure. It was a straightforward procedure, and the protocol was simple: to confirm the drug, the dose, and the patient. But in a rush, the defendant was negligent. She handed the task of preparing a syringe to an unqualified intern, an intern which she knew had a history of making dangerous mistakes. She didn't watch the intern fill it. She didn't ask him what was inside of it. And she didn't check it herself. And what ended up being injected into Mr. Henley? A massive, fatal overdose of ketamine. This wouldn't have happened if the defendant had confirmed the contents inside the syringe, if the defendant went to retrieve the drug herself, and if the defendant hadn't been negligent. But instead, just minutes later, Mr. Henley collapsed. A husband, a father, and a best friend gone. Not because of some terminal disease or an unforeseeable complication. It was her negligence that injected the wrong drug, causing her death. Today, as plaintiff, we bear the burden of proof, and we will prove by the preponderance of the evidence that the defendant committed 2 counts. Count 1, medical malpractice. We will prove how the defendant owed the victim a duty to meet applicable standard of medical care, yet still violated said standard by knowing how he failed to check this, and this failure was the ultimate cause to Mr. Henley's death. And count 2, wrongful death. After receiving care by the defendant, Mr. Henley died. His death was caused by the wrongful act of the defendant, and Mr. Henley and his estate suffered compensatable loss as a result of the defendant's wrongful act. We'll meet our burden of proof through our 2 witnesses today. You will hear from Mr. Henley's long-term best friend. She witnessed the entire scene. She will tell you how nothing was wrong and how nothing happened until the injection injected by the defendant. You will hear from an expert in drug analysis and how the defendant failed to check the label before injecting it into Mr. Henley, leading there to be ketamine in Mr. Henley's system. Members of the jury, today we're asking you to uphold a standard of medical care. This standard is the degree of standard and skill that a qualified physician in said field would provide to a patient. It was laid at the hands of the defendant. She did not meet that standard, and as a result, Arthur Henley paid with his life. The fact of today's case is simple. The fact was that the defendant was negligent. She didn't do her job right, and it took a life in return. Her negligence injected the wrong drug. Find the defendant liable. Thank you.
Thank you. Defense?
Yes, Your Honor. May I proceed?
You may.
May it please the court. The hospital mishandled the medicine. It's February 16th, 2025. Langford Hospital is overflowing. Patients packed into hallways. Nurses pulled into double shifts. Doctors sprinting from crisis to crisis. It is a system stretched thin. And right in the middle of it all is an overworked, undertrained intern named Finley Riveras. An intern who had already made mistakes. An intern the hospital knew was struggling, but an intern they kept anyway. That day, Miss Riveras is told to prepare an injection. Don't mess this up. But she does. She hands our client, Dr. Elias Hornby, a syringe she never should have prepared. Dr. Hornby administers it to a patient, Arthur Henley, and minutes later, Mr. Henley collapses. Minutes later, he dies. The plaintiff wants you to believe that this tragedy happened because Dr. Hornby's negligence injected the wrong drug. But the evidence will tell you something very different. That it was the hospital that mishandled the medicine. The plaintiff took on a burden today. They must prove, more likely than not, that it was Dr. Hornby's decisions that caused Mr. Henley's death. We, the defense, don't carry that burden. We don't have to call a single witness or show you a single piece of evidence. But we will, because the evidence reveals 3 facts the plaintiff cannot answer: the mislabeling, the mistake, and the mishandling. First, the mislabeling. You will learn that the medicine injected into Mr. Henley was labeled as a harmless sedative when it actually contained a dangerous drug, and the 2 drugs, nearly identical in appearance. The hospital mislabeled the drug. The hospital mishandled the medicine. Second, the mistake. You will hear that the person who prepared Mr. Henley's syringe was not Dr. Hornby. It was an intern, Finley Riveras, and you will hear how this intern was not competent. They had made mistakes before, even mixed up syringes. It was the hospital who mishandled the medicine. You will hear from the hospital's administrative coordinator, 12 years at Langford, nurse, supervisor, administrator, someone who knows how this hospital really works. She will tell you the hospital was understaffed. The equipment was outdated. The intern to supervisor ratio was dangerous. And that Mr. Riveras had been making mistakes long before Mr. Henley's death. The hospital mishandled the medicine. Third, the mishandling. You will hear how attempts were made to remove Mr. Riveras from clinical duties. Dr. Hornby, our client, will tell you how she asked the hospital to fire Ms. Riveras, and how the hospital refused. The hospital mishandled the medicine. This case isn't about arrogance or recklessness. It's about a system held together with duct tape finally breaking. As the hospital's administrative coordinator will tell you, hospitals are chain reaction environments. One weak link and everything falls. That weak link wasn't my client. It was the hospital. The hospital who mislabeled the medicine. The hospital's intern who made the mistake. And the hospital who mishandled the medicine. And when all the evidence has been presented, my co-counsel, Miss Anya Lowe, will stand before you and ask for the only verdict the facts support. Find Elias Hornby not liable. Thank you.
All right. Plaintiff, are you prepared with case in chief?
Yes, Your Honor.
All right. Please call your first witness.
Plaintiff now calls our first witness, Andy Parr, to the stand. Permission to proceed, Your Honor?
Yes, ma'am.
Good evening, Ms. Parr. Please introduce yourself for the court.
Hello, everyone. I'm Andy Parr, and I'm your local neighborhood grandma. The kids, they call me Grandma Parr, you see, and even if I'm a head full of gray hair, I'm still sharp as ever.
What is your occupation, Ms. Parr?
I worked as a vet for Sorry, numbers mess me up a bit. 30 years, and now I'm retired.
That's okay, Ms. Parr. So, how did you become a vet?
Well, I became a vet after studying in animal med school for a few years. I especially have to thank my best friend, Arthur Henley. I call him Artie. I mean, back when we were young, he helped me get a job shadowing experience with the local vet, and afterwards, I knew I had to become one.
What is your relationship with Mr. Henley?
As I've said just now, Arthur was my best friend. I've known him for 17 years now, and we baked cookies every Sunday at his mansion, and we were even planning on going on vacation together since we both retired, right? But I guess after all this, it's impossible now.
If you don't mind me asking, Ms. Parr, why is it impossible?
Earlier this year in February, I was accompanying Artie to go to the hospital for his regular treatments. I waited outside the operating room as he received it. And he's dead now, and it's all because of this one wrong injection.
What happened afterwards?
Objection, Your Honor.
Who was
Expert testimony from a lay witness.
All right. Please explain.
This witness just testified it's all because of one wrong injection. We understand that this witness was present and they were able to hear openings, so they do know some facts of the case. However, they're making an expert claim that the cause of death was directly from a syringe when this witness isn't able to testify to matters like that.
All right. Counsel for the plaintiff, what say you?
Your Honor, I believe that my witness just now was not trying to testify to how it was, not trying to prove how it was because of the injection, but she was merely trying to state what she observed, and from what she observed, it was that injection which caused the death of, which led to the death of Mr. Henley.
Last word, counsel for defense. How and specifically, why isn't this a rationally based perception based on her seeing what happened and being there?
Because this witness isn't an expert. They're not familiar with medical protocol. They're not familiar with how hospitals run, with how injections are done. So they're not able to use their rationally based perception to say that in a medical environment, something happened because another thing happened. Because they do not have the ability to recognize certain factors in that environment. And anything that they're testifying to is expert testimony.
Okay, I'll sustain the objection. Rephrase.
Yes,
Your Honor, may the testimony be stricken?
So stricken.
Yes, Your Honor. Ms. Parr, may I ask what happened after the treatment?
Well, he was soon released after his treatment, and everything was normal. But then, in a blink of an eye, as we walked to the car park, Artie collapsed, and He got sent to the ER and he just passed away a few minutes later.
I'm so sorry to hear that, Miss Parr. Would you mind if I walked you through what happened before that day?
No, I don't mind.
Miss Parr, what happened before you and Mr. Henley went to the hospital?
We went for brunch and we went straight to the hospital afterwards.
And what happened during the hospital visit?
We arrived at the hospital at about 2:30 p.m. We talked to this nurse and Artie was admitted right away for treatment.
And who treated Mr. Henley?
Someone called Elias Hornby.
What's your relationship with Miss Hornby?
Well, I don't personally have a relationship with Miss Hornby, but she's Artie's sister's child, so Artie's niece. And while Artie wasn't particularly close with him, I mean, he seemed like he trusted Elias.
Thank you, Miss Parr. Moving on. Was there anyone in the hospital besides you, Mr. Henley, and Miss Hornby?
Well, there were many, many people. I mean, it was really busy. I can't recognize all the faces, but I remember a Finley Riveras. He was also there. He was an intern under Dr. Hornby.
What was Finley Rivera doing there at the time?
He was in charge of getting the medicine.
And where was Dr. Hornby while Mr. Veras was retrieving the medicine?
I don't know. I mean, I couldn't see him. I only saw Finley at all.
Thank you, Miss Parr. And what happened after Mr. Veras returned with the medicine?
I was just a little worried since it wasn't Dr. Hornby herself who got the medicine. I asked about it, but her response, it didn't ease my worry since I was in the room the entire time and I didn't see her check the medicine inside the syringe before injecting it into Artie.
And
Objection, Your Honor. Expert testimony from a lay witness again.
All
May I
right.
explain?
What exactly was the offending testimony?
The testimony was that she was worried about Dr. Hornby's medical conduct because she did not see the doctor doing something.
Okay, and your objection is outside of her expertise, based on her not seeing something.
No, Your Honor. It's that this witness again is not an expert. They're not a doctor for people, so they can't testify to that certain medical conduct is good or not, which they just did, and they can't testify to certain things that Hornby did not or did do because they don't know whether Dr. Hornby would have done that before she could have seen him, or if she did it without her noticing.
All right, counsel for plaintiff, what say you?
Your Honor, I believe that my witness just now was not testifying to the conduct of Dr. Hornby, rather than how she was testifying to why she was scared. We weren't trying to the witness wasn't trying to prove that she wasn't trying to testify whether that behavior was good or not. She was just trying to testify to her emotions.
I agree. Overrule.
Yes, Your Honor. And Your Honor, may I re-ask this question?
It's your witness. You can re-ask it. You can move on. It's your direct counsel.
And Ms. Parr, what happened after Ms. Rivera's returned with the medicine?
I was just a little worried since it wasn't Dr. Hornby herself who got the medicine.
And did you do anything about it?
Well, No, I did not. I just asked about it to Miss Hornby.
And what did Dr. Hornby say?
She personally assured me that she already had triple checked the medication and that it was correct.
Thank you for your time, Ms. Parr. No more further questions, Your Honor.
Defense? Cross?
Yes, Your Honor. May I proceed?
You may.
Just a few more questions, Ms. Parr, and then you can go back to enjoying your retirement. Ms. Parr, you're not a doctor, right?
No, I am not, but I am a vet.
You're a vet, so you don't treat people.
Yes, that is correct.
You don't prescribe medication for people.
No, I do not.
You can't tell us what's good for people, right?
No, I cannot.
You can't tell us what people can or can't be injected with.
No, I cannot.
And ma'am, you don't even know what Mr. Henley was being injected with that day.
Of course I didn't. I just went along with him for some treatment.
Ma'am, I'd like to turn your attention to that syringe you saw. You don't know what was inside that syringe.
No, I did not.
You don't know the color of the liquid.
No, I did not.
You didn't know what drug it was.
No, I did not.
All you know is that an intern filled it.
Yes, that is true.
And you described the intern as stuttering, nervous, and shifting around.
Well, yes, but I'd understand. An intern is hard.
In fact, you thought the intern was very nervous.
Well, yes, that is true, but again, being an intern must be difficult.
You even heard other doctors warning Miss Riveras not to mix up the medication again.
Yes, that is true.
I'd like to turn your attention to Dr. Hornby. When the intern filled the vial, you were worried.
Yes, that is true.
You actually brought it up to Dr. Hornby.
Yes,
And Dr. Hornby said that the medication had been triple checked, correct?
yes, that is also correct.
And now, ma'am, you never saw Dr. Hornby act nervous, did you?
No, I did not, but she was a doctor. I suppose that was what's expected of her.
You never saw Dr. Hornby hesitate?
No, I did not.
The only people you saw hesitating or being nervous was the intern.
Yes, that is true, but again, we all have our first times.
Now, Miss Parr, I know this might be difficult for you, but you loved Arthur Henley like a brother, right?
Of course, that is true. We've been best friends for 70 years.
You want justice for him?
Yes, I do.
In fact, you've already decided Dr. Hornby is the one responsible, right?
No, absolutely not. What I believe is that anyone who should take responsibility for his death, they should be held accountable, not just Dr. Hornby.
So you're saying you don't want to hold specifically Dr. Hornby accountable?
No, I want to hold anyone that was responsible for my best friend's death to hold them accountable.
I'm not talking about anyone. I'm just asking. I'm just asking a specific question. You specifically hold Dr. Hornby responsible. Is that correct?
Well, we are not. I don't believe that Dr. Hornby is the only one responsible for all of this.
Ma'am, you aren't suing the intern.
Objection, Your Honor.
Basis?
Asked and answered. My witness has previously been asked this question twice, and she's answered Mr. Hill twice already.
Response, Your Honor?
No, I'm going to overrule it. That specific question is different. I might have sustained an asked and answer maybe 2 questions ago, but this one is different. You may proceed.
Yes, Your Honor.
You aren't suing the intern.
No, I'm not.
You're not suing the hospital.
No, I'm not.
All you're doing is suing Dr. Hornby. Is that right?
Yes, that is true.
And you're suing Dr. Hornby because you want to make Dr. Hornby pay. Is that right?
No, again, that is not true. I believe that whoever is responsible should be held accountable.
You're making an affidavit before today's trial?
Yes, that is true.
Would you recognize it if you saw it today?
Yes, I would.
Your Honor, requesting permission to screen share Andy Parr's affidavit.
You don't have to ask for permission.
Okay. Standing for the record, we'll be screen sharing Andy Parr's. Is this your affidavit?
Yes, it is.
Would you scroll to the bottom? That's your signature there?
Yes, that is.
Now, would you go to lines 134? Read along with me while I read out loud. I want to make sure they pay. I had a bad feeling about Elias Hornby the moment I met them. Something about a cold, distant, aloof from such a warm and generous man. Arthur saw something in them that I did not see. Now he's dead. So I'll ask again. You want to make Dr. Hornby pay. Is that right?
Your Honor,
No.
asked and answered.
I'll overrule.
Sorry,
No.
didn't you?
Again, they doesn't just mean Dr. Hornby. They can mean everybody, and that is what I strongly believe in.
Ms. Parr, I believe in your affidavit you continuously refer to Dr. Hornby as they, including in the lines that I just read, you continuously refer to him as they. So I'm going to ask just one more time. You want to make Dr. Hornby pay. Is that right?
And again, I still believe they, what I've said when I said they, it means everybody. It means that I want to hold everybody who killed, who had a part in making my best friend die accountable.
Thank you. Your Honor, no further questions.
All right. Based on that, any redirect?
None, Your Honor.
May this witness step down. All right, the witness has stepped down. Let's give it a couple of seconds for scoring purposes, and I'll let you know, plaintiff, when you could call your second witness.
Yes, Your Honor.
All right. Plaintiff, please call your second witness.
Yes, Your Honor. Plaintiff calls Dr. Alex Suzak to the stand. Good morning, Dr. Suzak. Could you introduce yourself to the court?
Good morning. My name is Dr. Alex Zuzak.
And what do you do for a living?
I'm the Director of Clinical and Forensic Pharmacology at Langford Hospital of Tilly.
What's included in your work?
My work focuses on making sure medicines are properly identified, delivered, and safe for patients. In a way, it's like baking a proper British pie, if you get what I mean. You need the right ingredients, otherwise the outcome can be harmful. And my job here is to check that what goes into the patient is exactly what it should be.
All right. What other qualifications do you have?
Well, I earned my master's degree and doctorate from Willow School in the field of forensic toxicology. And I've spent the last 15 years analyzing overdose deaths, drug mislabeling incidents, and failures in hospital drug protocols, which all contributed to my expertise in medical standards.
So, Dr. Suzak, what's your role in today's investigation?
I was contacted by the plaintiff to determine two things. One is what drug was injected into Mr. Arthur Henley, and second, whether or not there was any medical mishandling.
What materials did you review?
I have reviewed all witness statements, the autopsy report of Mr. Arthur Henley, and the syringe used during the injection of Mr. Arthur Henley.
So, how sufficient were these materials?
Well, they were sufficient enough for me to conclude my investigation with a reasonable degree of scientific certainty.
All right. How did you conduct this investigation?
I used the pie method. Now, fun fact here is that my colleagues and I thought of it on Pi Day, and I've been using it in each of my investigations ever since.
Let the record reflect plaintiff is screen sharing a visual aid made by Dr. Alex Suzak.
Yes. Was this seen by the defense?
Yes, Your Honor, it was.
Any objections?
Your Honor, if in the next few slides, if I see any objectionable material based on how it's used, can I raise then?
You may. All right. Please proceed, plaintiff.
Yes, Your Honor. So, Ms. Suzak, what does the pie method entail?
All right. So first, to clarify, each respective letter carries an important step of my investigation. So we have our first letter, which is P, which stands for prepare. I would stand for investigate. And finally, E would stand for evaluate.
All right. And how reliable is this pie method?
Well, it's the standard. Many of my colleagues and experts in pharmacology often employ this standard method when we carry out procedural investigations.
Okay. So, starting with P, how did you prepare?
First, we have our first letter, P, where I prepared my materials. I secured the syringe which was used during the injection of Arthur Henley and retrieved the remaining residue in the barrel of the syringe.
What did you do with the syringe during your investigation?
Next, I investigated by running some tests. I used a method called the High Performance Liquid Chromatography, or just simply call it the HPLC for short. What it does is that it separates different compounds to display if there's more than one compound in the residue. And I also used a UV detector to detect what chemical was inside the syringe.
Could you briefly explain how the HPLC method works?
Certainly. Now, the HPLC works by pushing the mixture through a narrow column under a high pressure of around 4,000 atmospheres, and these compounds would separate depending on how quickly they travel. Alright, to make it easy to understand, each compound is like a distinct ingredient in the pie. You can tell them apart once they're separated.
Okay, so how does the UV detector work?
It's basically like a flashlight, except it shines bluish light, and I shone the UV light onto the column. Now, lorazepam absorbs UV light, which should be picked up by the UV detector, but I found no traces of lorazepam in any of my tests.
So, what did you find from your experiments?
From my experiment, the chemical in the syringe absorbed the light as exactly 210 nanometers, which proves the chemical was most definitely almost entirely ketamine, as ketamine absorbs UV light around 197 nanometers or 210 nanometers. Furthermore, I reviewed the toxicology results from Mr. Henley's autopsy for confirmation.
Would you recognize a copy of the autopsy report if I showed it to you?
Yes, I would.
Let the record reflect plaintiff is screen sharing Exhibit 2, previously marked as the autopsy report of Arthur Henley. Do you recognize this exhibit?
Yes, I do.
Is it fair and accurate?
Yes, it is.
Who conducted this report?
Well, it was the coroner's office of the county of Willow.
And how often does this coroner's office do autopsy reports?
You see, the coroner's office investigates deaths, so every time after the investigation, they would make reports of autopsies of the deceased afterwards.
And is the coroner's office a part of the government?
Yes, it is. It belongs to the county of Willow, and you can also see the stamp of approval in the top left corner.
So would this autopsy report stem from an authorized investigation?
Absolutely. Since the coroner's office is a part of the government, this is entirely authorized.
Plaintiff now moves to enter Exhibit 2 into evidence.
Any objections?
Yes, Your Honor. Hearsay.
Response?
Your Honor, it's not hearsay as we've laid the foundation how this is a government record.
Seems like it would be. What say you, counsel for defense? Last word?
Your Honor, we believe that a government record does have many prongs. And, Your Honor, we don't believe that there's actually a specific exception under Rule 8036 that says it's specifically a government record. Rather, we believe the exception they might be referring to is 8038, public records. Could we get that clarified?
I'm pretty clarified. Public records, government records, I think it's synonymous here. So what say you specifically to what prong might be missing in the government public record exception?
Your Honor, in the case if it is a public record, then we think it's okay.
All right. Overrule. I'll allow it.
Yes, Your Honor. So, Dr. Zuzak, how does this autopsy report support your conclusions?
Well, I found that the ketamine level in the bloodstream was at around 3.6 Ug per millimeters, which was 10 to 12 times the typical sedation dose. And this is within range to induce coma or death due to its acute toxicity. And furthermore, as you can see, there is no lorazepam found in the deceased bodies at all.
All right. Well, moving on, Doctor, what did you evaluate?
I evaluated whether there was any medical mishandling during the injection of Mr. Arthur Henley using the materials I prepared, which, as I've mentioned before, were the witness statements.
And what did you discover about the defendant's actions?
I discovered that the defendant did not follow standard protocol.
Well, Miss Zuzak, what's the standard protocol?
Well, the standard protocol is to first check the contents of the drug. It's not just the label before injecting the patients. And then we need to know that the medical professional should double check the label and the physical characteristics of the drug itself. Now, in this case, there are notable distinctions between ketamine and lorazepam, which any physician would find as easy as pie to tell.
What's the difference?
So the notable differences include where ketamine has a slightly sharper odor, but there's also the viscosity.
What do you mean by viscosity?
Viscosity is essentially thickness, so you can move the liquid inside the syringe to check. Lorazepam is significantly thicker than ketamine and flows quite slowly, but the ketamine would flow much quicker than the lorazepam. To be able for you to understand, it's like water and oil, and you can do a bubble test to make sure.
Well, Miss Zuzak, what's a bubble test?
Well, before you inject a syringe, the air bubbles should be removed, just like when you bake a pie. So when a medical professional removes these bubbles, they should check how the bubbles are formed. Now, for the convenience of the jury, let me show you a visual aid. So,
Take it away.
Could you see?
Absolutely.
Alright, so here is a syringe containing ketamine, and I'll flip it over right here, like this. Okay, so as you can see, the bubbles in ketamine move very quickly, like water. If you can all see.
All right.
Now,
What about lorazepam?
now for the lorazepam, do you see it?
Yep.
Alright. We can see that the lorazepam seems like there isn't any air bubbles in this case, but then they also move slower because of the higher viscosity. It's just like oil, to be simple.
Okay. Well, doctor, moving on. Who retrieved the medicine?
Well, to my knowledge, it was intern Finley Rivera's.
And what's the standard protocol for retrieving medicine?
Well, it's never appropriate for a physician to let an intern fill a syringe without double checking its contents themselves before any action is taken. And in this case, Dr. Elias Hornby did not fulfill such a standard. So the responsibility always lies with the acting physician.
All right. So, what conclusion did you make?
Well, after conducting the Parr method and reviewing all witness statements, I concluded that 1. The only drug injected into Mr. Arthur Henley was ketamine at an acute toxicity, and subsequently it was overdose. And 2. Dr. Hornby was not overseeing the intern fully, hence its negligence.
No further questions, Your Honor.
Objection. Sorry, it's a little late, but it's the last response.
Okay, what's the objection? What's the basis?
Objection, Your Honor, as to improper expert testimony, specifically under Rule 702B, if I may be heard.
You may.
Your Honor, our issue is specifically to the last testimony about the intern. And while we agree Dr. Zuzek is very qualified as an expert witness, we have problems with the sufficient facts and data she needed to have relied on to form this conclusion. Because as of right now, there's no evidence on the record that Dr. Zuzek had any knowledge of the specific medical procedures at Langford Hospital. It's our understanding that she's not a physician, she didn't interview physicians, she didn't read over their policies with interns, so it's improper for her to include Dr. Hornby violated procedures she doesn't know exist.
Counsel for defense? Counsel for plaintiff, response?
Yes, Your Honor. So, as my witness has testified, she has been evaluating drug protocols for over 15 years, and so hence she is experienced in those protocols. And as you also heard, my witness is working at Langford Hospital, and she would know the protocols of Langford Hospital herself.
Okay, I'm sorry, just for my purposes, is that the same hospital where the incident happened at?
Yes, Your Honor.
Okay, and what say you specifically to plaintiff to defense objection that she wouldn't be familiar with the protocol specific to interns?
Well, Your Honor, we weren't asking on the protocol on interns, but rather the protocol on retrieving the medicine. And
Okay.
she's in.
Last word, understood. Counsel for defense, you mentioned that she wouldn't be familiar with the protocol, but she works there. And I'd imagine it'd be reasonable that she knows the protocol of a place that she works. Is that fair to say?
Your Honor, our issue isn't 702A, her knowledge. Our issue is with 702B, that she hasn't had the sufficient facts and data to form the conclusion about the policies of interns. Because as it hasn't been laid on the record, Dr. Zuzak works at the hospital, yes, but she's not a physician. And it hasn't been laid, she has interns, that she understands the policies with interns, and that she has all these facts and data to conclude Dr. Hornby breached a protocol with the proper intern procedure.
All right, that's easy enough. Counsel for plaintiff, can you lay that foundation?
Yes, Your Honor.
All right, go ahead. I'll sustain the objection for now. If you want the testimony, lay the foundation, and then we'll see if the attorney for defense still has an objection.
Yes, Your Honor. Motion to strike until a foundation has been laid.
I will strike it for now. Yes, ma'am.
Yes, Your Honor.
All right. Dr. Zuzak, so as you've mentioned just now, you're working at Langford Hospital, right?
Yeah, that's
Leading, Your
right.
Honor.
I find that this is just the lay foundation, so I'll overrule for now.
Yes, Your Honor.
So, Dr. Zuzak, you work at Langford Hospital, right?
Yes, that's right.
And what protocols are you familiar with?
Well, I'm familiar with the drug delivery systems as I need to make sure that the medical protocols are safe for the patients.
All right, and so let me ask you again, what conclusion did you reach?
Well, I reached that the only drug injected into Mr. Arthur Henley was ketamine at an acute toxicity, and subsequently it was overdose. And the second one was that Dr. Hornby was not overseeing the whole process of the injection, hence its negligence.
No further questions, Your Honor.
All right. With that said, counsel for defense, cross.
Yes, Your Honor. Good morning, Dr. Zuzak.
Good morning.
I remember a few minutes earlier in your direct examination, you talked a lot about a bubble method.
Yes, that's true.
The bubble method helps identify the difference between two substances.
Yes, that's right.
Well, it sounds like the bubble method is really important to today's case.
Well, yes, it is.
The problem is, Dr. Zuzak, you didn't write that bubble method anywhere in your affidavit.
Well, I did not, because in my affidavit, I wrote that there were notable differences. So today, I'm in trial to elaborate on what the notable differences are by using a method to show you.
How about we get that affidavit pulled up? Your Honor, for the record, we're now screen sharing Dr. Zuzak's affidavit that she wrote prior to trial.
Yes, ma'am.
Co-counsel, if we can get that up. Thank you. Doctor, this is the sworn affidavit you wrote.
Yes, it is.
We scroll to the bottom. Is your signature down there?
Yes, ma'am.
You had up to 24 hours to update this affidavit with anything important.
Yes, that's true.
Now, we could scroll through this entire affidavit, read it word by word, but I'm just going to ask you. Nowhere in this affidavit do you write about a bubble method.
No, I did not. However, ma'am, as I have explained earlier, I wrote that there were notable differences between ketamine and lorazepam, and today I'm using a visual aid for you to understand the notable differences by using a demonstration.
You wrote about notable differences. You didn't
Yes,
write
that's true.
about any methods to find those notable differences, did you?
No, I did not, yes.
Thank you, co-counsel. We can get that taken down. Well, next, Dr. Zuzak, let's talk about a few things we can actually agree on. Because we can agree Arthur Henley was injected with the wrong substance.
True.
We can agree it was ketamine, and not the lorazepam he needed.
Right.
We can even agree because of that injection, he died.
Yes, he did.
But let's see if it was the hospital who mishandled the medicine. Because right here, I've got a little drawing. It's not the best, but we'll call this apple pie and we'll call this orange pie. Now, we can agree apple pie and orange pie aren't the same thing.
Yes, of course.
If someone handed you an orange pie and called it apple pie, well, you might be a little disappointed, huh?
Right, I mean, I love pie, so I'd be offended.
Well, the hospital today, they made a mistake.
Yes, that's true.
They, in metaphorical terms, mixed up apple pie and orange pie.
All the pies. Yes.
They mixed it up because they actually mislabeled medicine.
Ah, yes, they did.
They kept a bottle of ketamine with the wrong label of lorazepam stuck on it.
That's true.
Doctor, that is dangerous.
Of course it is.
That is a mistake that can be deadly.
Right.
Because ketamine, lorazepam, they look the same.
They do look the same, yes. But there
But-
are notable differences.
Are notable differences, but if you just look at it in two syringes, they look the same.
I agree, yes.
Now, next, let's see whose negligence injected the wrong drug. Because, doctor, there was actually an intern involved in this whole process.
Yes, I'm aware.
An intern that filled the syringe.
That's true.
Now, doctor, this wasn't the world's best intern, was it?
That's true, yes.
The interns made mistakes in the past,
Right.
filled a syringe with the wrong substance.
Yes, and that is why our doctor should be checking the intern for the whole process of the injection.
Doctor, that wasn't my question. My question was, that intern filled a syringe with the wrong substance.
Yes, ma'am.
And Dr. Hornby wanted to fire her for this mistake.
Yes, I'm aware of this.
The hospital wouldn't let her.
That's true.
The hospital wouldn't let Dr. Hornby fire the intern because she had connections.
Connections. Yes, that's true.
And I noticed throughout this trial you keep circling back to the responsibility of the physician. But the truth is, Dr. Hornby didn't have any control when the hospital hired the intern.
Sorry, may I ask for clarification of what you mean by hired the intern?
Dr. Hornby didn't have control when the hospital decided to hire the intern.
Well, yes, he's not in recruitment.
Dr. Hornby didn't have control when the hospital refused to let her fire the intern.
True, but now you see, he's still under Dr. Hornby. So Dr. Hornby still has that responsibility to supervise fully on that intern.
Dr. Zuzak, that sounded like a yes. Dr. Hornby didn't have any control to fire the intern.
Yes, that I agree.
And certainly, Dr. Hornby didn't have any control when the hospital had mislabeled medicine.
Well, no, but he could have mitigated the whole investigation.
Doctor, is that it?
I'm sorry, what was an investigation? I meant the whole procedure, right? Because he was the acting physician, so he does have the responsibility from supervising the intern, from retrieving the liquid from the syringe to injecting it onto Mr. Arthur Henley.
Doctor, I can't help but notice you keep fighting me on some really simple questions. Let's see why you're choosing to cooperate with the plaintiff and argue with the defense. Because, Doctor, you weren't forced to be here today, were you?
Sorry?
You weren't forced to be here today, were you?
Oh, no, I wasn't.
Judge Simon didn't instruct you to be here?
No.
Your attorney didn't either.
No.
You're here because you're getting paid $75,000 to investigate this case.
Well, that's true.
$75,000, all paid for by the plaintiff.
Yes, because I had to use a UV detector, and that is very expensive.
Real simple question, Doctor. You're being paid $75,000 by the plaintiff.
That's right, ma'am.
Thank you, Your Honor. Nothing further.
With that, any redirect?
Yes, Your Honor, briefly. So, now, Miss Law mentions just now you were paid $75,000, but what's the proper pay for experts testifying?
Well, this is the standard pay. And moreover, the fees I requested are payment for specialized expertise required to conduct my analysis, which is the UV detector and the HPLC. And this is in the field of toxicology, and this allows me to come to my expert conclusion.
No further questions, Your Honor.
All right. Based on that, any recross?
No, Your Honor. Dr. Zizek can step down.
All right, Dr. Zuzak, please step down. Anything further from the plaintiff?
None, Your Honor. Plaintiff rests its case in chief.
All right, plaintiff having rest. Would you all like a brief recess or push forward through defense case in chief?
We'd be happy with a 5-minute break or whatever Your Honor prefers, but we're really fine with anything.
Same
All
with
right. Same with plaintiff? Okay, let's do a 5-minute recess just so we can all relieve ourselves if we need to, and then we'll be back for defense's case in chief. All right, does the defense have a case in chief?
Yes, Your Honor, we do.
All right, please begin.
The defense calls Riley Kwan to the stand. Good morning. Would you please introduce yourself?
My name is Riley Kwan. I moved here from Britain when I was a wee little thing at 15 years old.
And what do you do for a living, Miss Kwan?
I work as an administrative coordinator at Langford Hospital in Tilly.
What do you do as an administrative coordinator?
I supervise rotations, sign off on intern hours, and make sure the paperwork is up to date. If the doctors are the heart of Langford, the administration is the veins. Most people don't notice us unless we get clogged.
How long have you been at Langford?
About 12 years now. I started as a nurse, moved up to supervisor, and eventually into administration. I've done pretty much everything except operate on someone.
How did you get into healthcare?
Well, it all started when my sister came down with a nasty case of measles. I sat by her bedside, with a mask, of course, and nursed her back to health with some cracking good chicken soup. My famous recipe. After that, I knew I wanted to help people, but now I just wanted to help the hospital keep running.
How would you describe the conditions at Langford Hospital?
Chaotic. Honestly, we get taken more patients than our budget allows. The building is old, the equipment is dodgy, and working double shifts is common. We're understaffed and stretched thin.
What about the interns?
Pardon me. Interns are essential to keeping the hospital running, but the supervision ratio is rubbish. It's supposed to be 3 interns per person, but in practice it can be closer to 6.
Are the interns qualified?
Some are brilliant, but others I wouldn't trust anywhere near a hospital, let alone treating patients.
Did you know the intern Finley Riveras?
Yes, I've seen them around the ward and am aware of their connection to Arthur Henley and Dr. Hornby.
How would you describe Miss Riveras as an intern?
I like them. They're bright and hardworking, but she gets in her own way. When she moves, well, she moves too fast, and it wasn't a secret that she had made mistakes before.
Let's talk about February 16th, 2025. What was the hospital like that day?
In shambles. We were short 2 nurses in the East Wing, and the ER was backed up from a bus accident, and I hadn't been able to find a single replacement.
Did anything else happen that day?
A patient, Arthur Henley, died after he had been treated earlier that day. I remember that he was treated by Dr. Hornby and Finley.
After that incident, what were your responsibilities?
I had to create the incident log. I started by pulling the chart and medication log. Everything looked hunky-dory at first.
What changed?
Well, later I received a lab report that showed that Mr. Henley had ketamine in his system. Ketamine isn't something that just sneaks in, and it means that something has gone seriously wrong.
What could have gone wrong?
While it is impossible to say for sure, a large possibility is that the cleaning process that the syringes went through wasn't thorough enough.
What was wrong with the cleaning process?
Our hospital is supposed to use an autoclave to clean syringes, which cleans via highly pressurized steam, but it's been bust for weeks.
What did the hospital do instead of using an autoclave?
We had to use a manual cleaning process using a chemical solution, but if it isn't done exactly, then residue can linger, especially highly concentrated solutions like ketamine.
Did you raise concerns about the new cleaning process?
Yes, I did. I emailed the facilities director 3 times. I even had a laugh with the charge nurse that it was going to bite us. I never met like this.
In your experience, how does a hospital like Langford contribute to incidents like this?
Hospitals are chain reaction environments. When one thing goes wrong, like staffing shortages, broken equipment, or an overwhelmed intern, everything down the line fails. It's not as neat as it being a single person's fault.
Thank you. Your Honor, no further questions.
Thank you. Based on that, any cross?
Yes, Your Honor. Good morning, Miss Kwan.
Top of the morning to you.
Miss Kwan, you're currently only an administrator, coordinator, correct?
Yes, ma'am. But like I've said, I've gone through multiple stages in the hospital. I've been a nurse. I've been many other things too.
And Miss Kwan, you aren't a doctor, are you?
No, ma'am, but I did serve as a nurse before becoming an administrator.
You can't read people's minds, can you?
No, ma'am. If I were that, I'd become a psychic.
So you can't and don't know whether or not the defendant felt overworked. Is that correct?
No, ma'am, but given the conditions of the hospital, I would assume.
Is that a yes to my answer? You
Yes,
don't
ma'am.
know. Thank you, Miss Kwan. Moving on. You did an internal review with Miss Finley Riveras, is that correct?
Yes, I did.
And you are aware that Finley was the one who retrieved the medicine, is that right?
I am aware of that. Yes, ma'am.
However, you cannot be sure where Miss Riveras got the syringe.
No, ma'am, I can't be too sure. As I
And
wasn't there at the time. Sorry.
it's okay, Miss Kwan. And you can't be sure whether or not the syringe Miss Riveras took was contaminated. Is that correct?
No, ma'am, I can't be too sure if the syringe was contaminated or not.
And you can't be sure whether or not Miss Riveras had used a clean syringe. Is that correct?
No, ma'am, but anything could happen, you know?
Thank you, Miss Kwan. Moving on. Miss Riveras was given a note. Is that right?
Yes, she was.
And you don't know what the note was talking about, do you?
No, ma'am, I don't. Like I said, I'm not a mind reader.
And you don't know the context of the note?
No, ma'am, I don't.
And then, by your logic, you could not have known what the note given to Finley Riveras could be implying. Is that correct?
No, ma'am, I don't.
Thank you, Miss Kwan. Let's move on. You talked to the defendant, Dr. Elias Hornby, after Mr. Henley's passing. Is that right?
I did.
And you heard the defendant say herself, I should have checked it myself. Is that correct?
Yes, ma'am, I did hear them say that.
She even repeated this sentence 3 times. Is that correct?
Yes, she did.
But let's talk about what you didn't hear Miss Hornby say. You didn't hear Miss Hornby say the autoclave failed, did you?
No, I didn't hear her say that.
You didn't hear her say that the hand washing failed, did you?
No, I didn't hear her say that, but as I said, the autoclave's been bust for weeks. Everyone knew that.
And you didn't hear her put the blame on anyone else?
Well, yes, if I lost a family member like that, probably blame myself too.
Miss Kwan, that is not my question. My question is that you didn't hear Miss Hornby put the blame on anything else. Is that right?
No, ma'am, I didn't.
She was only saying how she should have checked it herself. Is that correct?
Right, but she was in a very emotional state at the time.
Thank you, Miss Kwan. No further questions, Your Honor.
All right. Based on that, any redirect?
No need, Your Honor.
Okay. We will take a moment and call. We'll take a moment, and when ready, I'll ask for the defense to call their next witness. All right. Defense, are you ready to call your next witness?
Yes, Your Honor. We call Dr. Elias Hornby to the stand.
Okay.
Good morning, ma'am. Could you introduce yourself to the court?
Good morning. My name is Elias Hornby.
What do you do for a living?
Oh, I'm an attending physician at the Langford Hospital, and I specialize in internal medicine. I'm also the full-time mother of my lovely boy Jamie, and I live right here with my husband in Tilly.
How'd you get into that line of work?
I actually started out studying molecular biology, but when my mom was diagnosed with lung cancer back in 2003, I saw what a good physician could do for a family. And that's when I knew I wanted to be the one giving that care.
Doctor, where did you go to school?
I went to school at the University of Tilly to get my bachelor's, and then I got my medical degree from the Tilly School of Medicine. I then completed my residency and fellowship at the Little Hamlet General Clinic.
Can you tell us about your professional experience?
Of course, after getting my medical degree, I worked at the Langford Hospital since 2017, and I've been actively practicing medicine for 13 years now.
Now, before we go any further, do you know why you're here in court?
Yes. They're blaming me for my uncle's death.
Ma'am, I just want to make this clear. You heard the plaintiff say today your negligence injected the wrong drug. Is that true?
No, that's not true. Listen, I've spent my entire life saving people. I never skipped safety checks because the safety of my patients is on the line.
Thank you for help clearing that up. Now let's spend some more time talking about your professional background. What's it like working in the hospital?
It's exhausting. We're always busy, so our staff is constantly overworked, and I've had to take on more interns than I can manage just to keep that hospital running.
From what you know, is this consistent throughout the hospital?
It is. We rely on interns, even if they aren't qualified, to treat all the patients. And our hospital isn't the best, so our equipment is old and we all work double shifts. It's a hard job, but I would choose it over anything else. Because I know I can make a difference in people's lives. Until the day I treated my uncle. February 16th. It's a day I'll never forget.
Can we talk more about that day? Is that all right with you, ma'am?
Yes. Yes, I need to clear the air.
Okay, so doctor, what happened on February 16th, 2025?
It was supposed to be a routine checkup. It was a routine checkup. My uncle needed treatment for his mild anxiety, and I was the one giving it.
Is it normal for you to be treating a family member?
Not exactly. Normally, they don't have family treat each other, but the hospital was so understaffed that they needed me to do it, and Henley asked for it.
So how did you treat your uncle?
He needed an injection of lorazepam, so I gave my intern very clear instructions on how to fill that syringe with the right drug. And then I looked it over and I gave my uncle that injection.
Would you recognize a picture of that syringe if I showed it to you today?
I would.
Your Honor, for the record, the defense is now screen sharing Exhibit 3.
Yes, ma'am.
Dr. Hornby, is this a fair and accurate copy of that syringe?
Yes, this looks like a picture of the syringe I used.
The defense moves to enter Exhibit 3.
Any objections?
No objections, Your Honor.
All right. Accepted.
At this time, Your Honor, we also direct the court's attention to Stipulation 16, which states the syringe depicted in Exhibit 3 was supposed to be filled from a bottle labeled lorazepam. The bottle was tested and found to not contain any lorazepam. So, doctor, did you have any reason to believe that this syringe was filled with anything other than lorazepam?
No, no reasons. I needed lorazepam. It was handed to me as lorazepam. There was nothing else to indicate otherwise.
Were you able to double check the syringe?
Yes. As always, I looked it over. The color looked exactly like lorazepam, so I injected it.
Doctor, do you know what went wrong?
No, ma'am. I have no idea what went wrong. The label on that syringe was accurate, no doubt. I remember it said lorazepam, not ketamine, I'm sure.
Who filled the syringe?
My intern did. Finley Rivera's.
Did you have any concerns about your intern?
Ma'am, of course I did. Finley's made mistakes before. Mistakes that put the lives of my patients in danger. When she filled a syringe with the wrong drug, I wanted to fire her. My supervisor told me to give her another chance.
What do you mean by that?
Her family has connections with my supervisor. Apparently, her family was residents or something like that.
So, could you have fired your intern if you wanted to?
No. And as a physician, I don't have a say in who gets hired or fired. That's all decided by my supervisors and hospital admin.
Why did you choose Finley Rivera's to fill that syringe?
I didn't. Ma'am, I didn't have a choice. She was the only one there that day, and she was the only one I had at the time who was available.
Well, looking back, what do you know about the events leading to Mr. Henley's death?
Ma'am, it's scary how I did everything in my power to keep my uncle safe. But it was useless. I gave my intern the simplest of jobs: take a clean syringe from the drying rack, fill it with lorazepam. And then when I found out about my uncle's death, I did everything in my ability to find out what went wrong.
What did you discover?
I found that there was ketamine in the bottle, not lorazepam. And then I find out that the medicine's being mislabeled. Ma'am, I trusted our hospital to keep our patients safe. If only I didn't, my uncle would still be here today.
Thank you so much for your time today, Doctor. Your Honor, I have no further questions.
Okay, with that, Cross.
Yes, Your Honor. Before that, Miss Hornby, I'd just like to give you a moment.
Thank you, ma'am.
No worries. So, Miss Hornby, you've been a doctor at Langford for more than a few years now, right?
I'm sorry.
No
Yes,
worries.
that's right.
And I'm sorry to mention your uncle, but you've treated him at least 8 times, right?
That's right.
And they've all been about lorazepam treatments, right?
Right.
And as you've mentioned just now, it was supposed to be a routine checkup, right?
It was.
All right, so just now you mentioned you never skipped safety checks, right?
That's right.
And as a physician, it's your duty to check your intern's work, right?
That's right. It's my duty to administer a drug and make sure I'm giving the right one.
Well, you even mentioned how you should be double checking the contents of everything interns did, right?
That's right. And I did.
Well, ma'am, as we all know, this intern, she previously made mistakes.
That's right, ma'am. I wanted to fire her. My supervisor wouldn't let me.
She even filled a syringe with the wrong drug, didn't she?
That's exactly right, ma'am.
But Miss Hornby, you weren't there to look at the intern getting the drug, were you?
I'm sorry, ma'am?
You weren't there when Miss Rivera's took the drug, were you?
That's right. I told her to fill a syringe with the razpam, and then I went to see another patient.
So, you weren't there to supervise the process.
That's right. I told Finley to fill a syringe, and then I went to another patient.
All right, and checking whether the drug is correct is important, right?
It is. Yes, ma'am.
And if the wrong drug was injected, there could be serious consequences, right?
Of course, ma'am. It's dangerous to inject the wrong drug, and that's why I always double check to the best of my ability.
Well, you were here during Andy Parr's direct, weren't you?
Yes, I'm familiar with Miss Parr.
And you told her how you would triple check.
And that's right. I triple checked that syringe to the best of my ability, which included looking at it, and it looked like lorazepam, so I injected it.
Well, Miss Hornby, just now you told us today that you
Objection,
only
Your
double.
Honor. Just procedural, if I may briefly explain.
What's the basis?
We ask, it's more of misstating the record, if I can just quickly clarify.
Okay.
We asked Miss Suen refer to Dr. Hornby by her proper title, not ma'am or miss, but doctor, and give her the respect her title deserves.
All right. I'm gonna overrule that.
Yes, Your Honor.
Yes, Your Honor. So, Miss Hornby, injecting the drug, there could be serious consequences such as death, right?
In extreme cases, yes, ma'am.
And now you assured Miss Parr that you triple checked, but just now, as you've told us today, you only double checked.
I'm sorry, ma'am?
Just now, as you told us today in court, you told us today that you only double checked the syringe, right?
Ma'am, I made sure to double check anything that intern gave me, but that day I did triple check that medicine.
Well, Miss Hornby, you're in court today, and just now you told us that you double checked the syringe, right?
And that's right. I triple checked it, which included double checking it.
Well, now Miss Hornby, let's walk through how you checked the syringe. So you checked the color, right?
I did. The color
And you
looked exactly like lorazepam.
all right, and you checked the label.
That's right. And it was labeled lorazepam on the vial.
That's 2 steps, isn't it?
That's right.
That's not 3 steps, right?
No, ma'am, I don't need 3 steps.
Now you're telling us today you don't need 3 steps, but then just now you assured Miss Parr that you triple-checked the syringe?
That's right. I triple checked the color, it seemed right, and I looked at it. It said lorazepam.
Miss Hornby, you're still only telling us 2 steps, right?
Ma'am, I don't need 3 steps to triple check something.
Miss Hornby, you do understand that triple means 3 times, right?
That's right. I checked the syringe 3 times.
Well, as you've told us today, you've only taken 2 steps, right?
Objection, Your Honor. At this point, asked and answered. It's been well established. Dr. Hornby took 2 steps to triple check.
I am finding it a little cumulative, so I'll allow you just one more question for clarification purposes only, counsel for plaintiff.
All right. So, Miss Hornby, again, 2 steps only, not 3 steps, right?
Ma'am, the number of steps and how many times I checked the syringe don't correlate.
So that's a yes to my question? Only 2 steps.
That's right. I used those 2 steps to triple check that syringe.
No further questions, Your Honor. Your Honor, I believe you're muted.
Apologies. With that, any redirect?
No need, Your Honor. Can Dr. Hornby step down?
They may.
And with that, the defense rests its case in chief.
All right. Defense having rested, do you all want to go to summations now or take a bit of a break before summations?
Your Honor, could we have a 5-minute break?
All right. We'll have another 5-minute break just so you all can get your thoughts together for closings. All right. Defense having rested, plaintiff having rested. Plaintiff, are you ready for summations?
Yes, Your Honor.
Please proceed.
Your Honor, members of the jury, may it please the court. Her negligence injected the wrong drug. Now today, we've heard a lot about the environment, but what about the actions? Because we've proven to you today, the defendant's actions weren't enough. She didn't meet her standard of medical care because she didn't take enough actions. Now today, as plaintiff, we have the burden of proof by the preponderance of the evidence, and we've satisfied it. So, if there's even a slight chance that our evidence makes much more sense than defense, you must return a verdict for the plaintiff. And we've proven it to you today, the count of medical malpractice and the count of wrongful death. So today, there were 4 witnesses that went on stand. Let's start with Miss Parr, Mr. Henley's best friend. Now, she was there. She witnessed the entire scene, but in the end, she didn't see the doctor supervise the intern. She didn't see the doctor check the syringe, and after all that, Mr. Henley died. You've also heard from Miss Riley Kwan. Now, she didn't know whether the defendant felt overworked. But there's one thing that she does know. The defendant should have checked it herself. Exactly what the defendant said in her own words. She didn't blame the hand washing. She didn't blame the autoclave. And Miss Kwan didn't see any signs of her being overworked. She only saw how the defendant blamed herself. And now, let's move on to the defendant. So, she told you how she checked the label and the color, but you heard nothing else. She told 2 steps not free. And members of the jury, as we all know, triple equals to 3 steps. But she told you today there was only 2. There was never a 3rd step. And even in her direct today, she originally said she double-checked. But then on cross, she just suddenly says that she triple-checked. Well, then why didn't she first clarify that she triple-checked in the first place? Because she didn't, and she lied to Miss Parr. She told Miss Parr how she triple-checked, but then she tells you all today that she double-checked. She's contradicting herself. And she even allowed her unqualified intern to get that drug unsupervised. And afterwards, the drug was found to contain ketamine and not the syringe was found to contain ketamine and not lorazepam. And Mr. Henley died. We've also brought an expert to you today, members of the jury, Dr. Alex Suzak. And she's told you today about the viscosity, that lorazepam is thicker than ketamine, and that it's very easy to check with her bubble test. But as you've still heard from Ms. Hornby, she didn't check the viscosity, and she didn't check, and that was why she breached the standard of medical care. Because if you don't check, as you've heard from her today, there could be serious consequences, and the consequence today was that Mr. Henley died. Now, members of the jury, the defendant had the syringe, and the defendant could have checked the viscosity, but as you've heard today, the defendant didn't check the viscosity. And now, Mr. Henley is dead. Her negligence injected the wrong drug. I urge you to find the defendant liable. Thank you.
Defense?
Yes, Your Honor. The hospital mishandled the medicine. Now, we heard today a lot about a doctor in the hospital she worked at. There's a few things we agree on. We agree the doctor had the training. We agree that, in fact, she's properly treated the patient several times in the past. And we also agree that the doctor had followed standard procedures. But things went wrong when the hospital forced her to keep an untrustworthy intern and kept mislabeled medicine in their supplies. And the plaintiff tried to argue today that her negligence injected the wrong drug. Members of the jury, we agree there was negligence. But it wasn't the doctor's negligence. It was the hospital's, because they mishandled the medicine. And that is why we are here in court today. Because the plaintiff has something to prove against Dr. Hornby. They have a burden to prove more likely than not my client committed both medical malpractice and wrongful death. And really what that means is if this case comes to a 50-50 split and you don't know what to choose, well then you gotta go with not liable. Members of the jury, they failed to meet that burden this entire trial because we made sure to triple check with not just 2, but 3 steps. The mislabel, the mistake, and the mishandle. First, the mislabeled medicine. Members of the jury, you learned from the plaintiff's own expert witness on cross-examination that the hospital kept mislabeled medicine. They had a bottle of ketamine with a wrong label of lorazepam stuck on it. Members of the jury, I don't need to tell you how dangerous that is. It is the equivalent of someone mislabeling rat poison as dog food. Because the hospital mishandled the medicine, a patient died. But second, the mistake the intern made. Because every single witness who testified on stand today had something bad to say about that intern. For good reason, too. Because the intern that Dr. Hornby had filled the syringe with was completely incompetent. She misfilled syringes in the past, forgot to sanitize them properly, and made all sorts of mistakes that should have gotten her fired. So finally, let's talk about how the hospital mishandled this situation. because you heard from several witnesses today how Dr. Hornby wanted to fire that intern. She wanted to fire her for the mistakes the intern kept making, but the hospital just wouldn't let her because the intern had too many connections. Those aren't the mistakes of a doctor. Those are the mistakes of a hospital. Now, the plaintiff today, they talked a lot about the duty of care Dr. Hornby owed the defendant, how they owed a duty of care and how Dr. Hornby violated it. And yes, we agree. Dr. Hornby did have an obligation to take care of Mr. Henley. Members of the jury, she's not all-knowing. She gave the intern clear instructions, double-checked the syringe to the very best of her ability, and administered the treatment. And we want to make it clear. Dr. Hornby herself testified today that the physician isn't responsible for filling the syringe. She's responsible for administering it. It is perfectly all right for her to tell her intern to fill the syringe. That is exactly what she did. She expected lorazepam. The label was lorazepam. But because of things that were out of her control, everything went wrong. Now, throughout her closing argument today, Ms. Swan brought up the 4 witnesses called today, one by one. It's funny, in all those minutes that she brought them up, not once did she talk about how the plaintiff witnesses lied on stand. Because as you remember from today's trial, both of their witnesses are biased, and both of them were impeached. Andy Parr, first witness they call, the eyewitness, was impeached today, trying to protect her own biases. She was very adamant that she had nothing against Dr. Hornby, but once her affidavit was pulled up, it was very clear she wanted Dr. Hornby to pay. That is the whole reason why she brought charges against the doctor and not the hospital. She's blinded from reason. And their second witness, the expert who the jury should trust for reliable information, also lied on stand. In return for $75,000 she's being paid to testify, the expert tried to prove Dr. Hornby didn't double-check by making up a method on stand. A very important bubble method they didn't bring up once in their entire expert report. Members of the jury, all these plaintiff witnesses lying on stand, it is a clear sign of a desperate plaintiff who's willing to bend the truth to win this case. What you learned from the defense witnesses today about a hospital who overworked their doctors. A hospital so understaffed, so careless, they kept a mislabeled medicine. A hospital who refused to let their doctors fire faulty interns because they needed the help. It was the hospital who mishandled the medicine. Now, earlier in today's trial, we pointed out case law Minerva Rickman. If you remember, it states that doctors don't have to guarantee a successful outcome for a patient, and an error is not automatically considered a breach in care. Sure, Dr. Hornby made mistakes. But I want you to remember that she's human too. She makes mistakes just like the rest of us, and that doesn't make her negligent. As members of the jury, Dr. Hornby had no control over the mislabeled medicine. Dr. Hornby had no control over the intern's mistakes. Hornby had no control over firing or hiring that intern. The people who did have control was the hospital. And they made the mistakes when they mishandled the medicine. Find Dr. Hornby not liable. Thank you.
All right, plaintiff, I believe you have 1 minute and 45 seconds for rebuttal.
Yes, Your Honor. The mistake was on the doctor, not the intern, because of one simple fact. She was negligent. Members of the jury, it wasn't the plaintiff witnesses who lied today, but the defendant herself, on stand. You heard how she kept contradicting herself. On direct, she tells you she double-checked, and on cross, suddenly this double, it turns into a triple. She tells you how she triple-checked, on cross only, but not on direct. And members of the jury, now, if this intern couldn't be fired, if this intern could keep her job, and if the defendant was so concerned about this incompetent intern who previously made mistakes, Well, she wouldn't just tell her intern to get the drug. She should have checked the entire process. And as you've heard from the defendant herself, it's her responsibility to check the contents of everything the intern did. Yet she didn't. She wasn't there during the process of getting the drug, and there ended up being the wrong medicine. Her negligence injected the wrong drug. Find the defendant liable. Thank you.
All right. Anything further, plaintiff?
None, Your Honor.
Anything further, defense?
No, Your Honor.
And that concludes our trial. All right. Congrats, both teams. So we're gonna give you all some overall feedback for both teams. And then after that, Dr. Lambert will announce who will be moving on to the finals. But no matter who moves on, I think both sides should be very proud. So you all have heard from me the last couple of hours. So let's hear from some of your other judges about their feedback. Judge Katz.
Sure. It was a fun round. I really enjoyed watching. There were a lot of great moments. I want to highlight one in particular that was my favorite part of the trial. I mean, this kind of happened twice, but Miss Luo, like you used the structure and then related it back to either your theme or something that you had brought up in your direct examination. Then it happened in close again as well. I think I like the close one more just because it, in the back half of the trial, this issue of the double checking versus the triple checking became such a point of contention. And then you went, bam, actually it's not that at all. It's just our theme, which was great. I really, really enjoyed that. I'm a judge who really appreciates responsive moments, impromptu moments, and that just demonstrates such a command over the facts that you're able to suddenly operate basically outside of them is just really high level stuff. I think across the board, the witnesses were very, very engaging. I really appreciated the plaintiff doctor. I really appreciated the defendant. Lots of great energy, lots of great responsiveness, fun characters too. I think in general, I would love to hear on objections some more actual rule number citations. That's, as a judge, is just always more convenient to have something to attach there. One thing I would say as well, some of us did this better than others, and this is a piece of feedback that I give to most people I judge online. But if you look at the Zoom screen you're on, that's what I'm doing right now. Versus if you look at the camera on your computer are two completely different things from a judge's perception of how you're communicating through the screen. So just make sure that you're looking at the camera on your computer, not the screen itself. It just comes across as much more engaged, much more communicative to the judges. But thank you so much for allowing me to judge. It's been a pleasure.
Okay, Judge Latha.
Yes. All right. I'm just gonna go through some of my comments on my feedback form. But overall, everyone did a really great job. I can see why you all made it to the semifinals. Very high level performances by all the attorneys and all the witnesses. Yeah, I mean, I just wanted to reiterate some of the comments that Judge Katz made. Same thing about objections. Sometimes I felt like some of these objections were really kind of reaching. Like call my witness by their title. That's not really an objection. So it would be good if your objections were based on rules. And I know that like not all legitimate objections have rule numbers. I get that. Like asked and answered or whatever. But I look for, both as a coach, mock trial coach, and a judge, I look for objections that can be argued based on rules or or something solid. So I would just concentrate on arguing those kinds of objections. I also wanted to make the point that for you to have an effective impeachment, there should be a direct contradiction in the witness's affidavit, either a direct contradiction by verbiage or by omission. So, for example, if somebody says something on the stand and you say, where, is you don't mention this anywhere in your statement, right? It should that's an impeachment by omission, and that's fine as long as it's really not there anywhere. Same thing with impeachment, normal impeachment. If you're going to impeach someone, make sure that what you're impeaching them on is exactly what is or is not written in the statement. There was an argument on whether the word they referred to one person or multiple people. I don't know why it was written that way, but it was. And frankly, that is up to dispute. You're having the witness saying that she was referring to multiple people. The attorney was trying to get her to say that she was referring to one person. And then there was what appeared to be an impeachment attempt. The witness was asked multiple times, so you're meaning, I can't remember the doctor's name, but, and she said, no, it's multiple people. Just leave it at that. I don't know if that impeachment was effective. So for impeachments, you have to be really careful. And I know that impeachments are super exciting. And, when I did mock trial, that was what, they're fun. And when I did actual trials as an attorney, I impeached the main witness on the other side once in a real trial, but it was an exact opposite thing. I mean, they said one thing in their deposition and they're literally trying to say something else. And that fact was crucial to the case that I was litigating. Like, it actually went straight to liability. I mean, like, I had to address it. So it should be, impeachments need to be precise, or else they're just not going to come off as strong. So that's just a general overall. Sorry, I'm a coach, so so as a coach, I look to see where I can talk to students about improving. So if I talk about something that you did or didn't do, I'm not picking on you, or and if I don't mention you, I'm not ignoring you. I just like to help students become the best mock trialers they can. And if you guys go on to become lawyers, hopefully this will help. But another thing, sorry, before I go into specifics, another thing is I really loved, both sides did a great job on reiterating, first, stating your hooks and your themes and your theories, and then reiterating them back on closing. So I thought you guys did a really good job. That shows that you coordinated with each other, within your team, and really had a solid idea on what you wanted to express during the trial. So I really like that. Yeah. So the opening attorneys both did this, and I guess it's not wrong or right, but I thought it was curious. So, like, the plaintiff's opening, Ms. Choi, you talked about the witnesses that you were going to call, but you didn't give them a name. You just said what they were. If the judge/jury is going to be hearing from somebody, give them the name in opening. You can give them the name without being gender specific if you don't know the gender on the other side or your side or whatever. But, like, I'm not sure why the actual names of the witnesses were not given. And the same thing on defense opening. You named Finley Riveras, but then when you talked about your second witness, I can't, but you just mentioned them by, that they were going to be called on the stand, the hospital administrator, but you didn't give them a name in your opening, which I just thought that was curious. I'm just used to hearing names of the witnesses. If you're going to refer to them in your opening, like you're going to be calling them, so give them a name so that people remember them when you call them up. Sorry, I'm just trying to look at the improvement comments that I made. The comments that were good, I'm just going to let you guys read them. Okay, I talked about that. Good use of exhibits, by the way, on both sides. Excellent job. Yeah, so this bubble method thing, I thought that the cross-exam did a great job of bringing it up on the Alex Zuzak direct on the cross of Alex Zuzak, that there was no mention of the bubble record in her witness statement. And I'm wondering why it was even brought up on direct if it was not on in the statement, and why did the opposing counsel not object during the direct when it was brought up, saying that it was outside the scope of the statement? This is the first session or whatever that I'm judging this mock trial tournament. I've judged like many of them over 20 years. This is the first time for this one, and I don't know if there's a rule. I mean, typically speaking, you can include things in testimonies at tournament that are not specifically stated in the statements, as long as they're, reasonable and a reasonable extrapolation. You can't make, go beyond the pale and make stuff up. But I thought it was curious that you brought up an entire theory, a bubble method, that's not in your statement. And so I thought the crossing attorney did a great job of bringing that up, but I don't know why you didn't object during direct. If they're completely making up something that's not in their direct at all, or I'm sorry, not in their statement at all, that is a legitimate objection for beyond the scope of the statement. So I was a little curious about that. But you brought it up on cross, so that was great. This is more of a stylistic criticism, and this is regarding the whoever did the cross of Riley Kwan. So I don't want to take time to look it up, but in my opinion, both as a former competitor and as a current mock trial coach and as a judge, when you're on cross and you say, let's move on, usually you say that when you tried getting an answer out of a witness and you tried multiple times and it just didn't work, and you're like, okay, fine, let's just move on. But you use that whenever you wanted to switch topics. And so this is a stylistic recommendation. Instead of saying, let's move on, because I'm used to hearing that when people get frustrated and they're like, I'm not getting what I want from this witness, I'm just going to move on. And then you say, let's just move on. I would say something like, I would like to turn now to, blank topic, or, okay, thank you. Let's move on now to talking about blah, blah, instead of saying, let's just move on. Again, stylistic, just a recommendation. The cross attorney on Elias Hornby, I thought, so you had a very emotional witness. Vivian did a really good job of being emotional as a witness, very, very good natural acting there. And so she was, quite upset. The witness was quite upset at the beginning of cross-exam. And you did a really good job of the person who crossed her. And I'm sorry, I don't have all the names here. In the very beginning, you were very sensitive to her starting your cross-exam. And I think, like, as a person who litigated, that's a really important skill to have. I mentioned earlier that in real life litigation, I once impeached, the main witness on the other side. Well, let me just tell you, this guy was, I kid you not, he was in his 80s. He looked like everyone's grandfather. And this was a jury trial, so I had a jury watching me. He looked like, like I said, he was in his 80s. He was still involved in this company. So he was like my main witness on the other side. I had deposed him and everything. He looked like everyone's grandfather. Everyone on the jury probably looked at him and thought of their grandfather. you know, I could not be like this aggressive, mean person on cross exam to an 80-year-old grandfather looking witness, even though, you know, I would get him on the facts. But you have to be sensitive to the witness that you have on the stand, whether it's a mock trial or a real trial. I mean, we know that here it's a mock trial and the witness is not actually crying, but nevertheless, you know, the cross attorney shouldn't get up there and just go into it and be like, "Arr!" and you didn't. The cross attorney did a great job. She recognized that, oh great, I have a crying witness on the stand. And she's like, let's take a moment, you know, sorry, and all that. But then you still went into your direct or your cross and got what you wanted. And you were very sensitive. You didn't raise your voice. I think that is to be commended, because at mock trial, it's very easy to like be very focused on the fact that you're in a competition, and you may not take into consideration, you know, like the real life aspects of how you're acting. So I just wanted to give you a big compliment on how you handled a crying witness when you're going up on cross. Okay. Yeah, I mean, I think that's all the specific kind of improvement type comments that I had. I gave a lot of you a lot of compliments, but you can read that in your feedback. So thank you.
Thank you all very much. All right, everybody. Thank you to our esteemed judging panel for giving these comments, both the verbal ones you received and the written ones you're going to be getting as soon as these announcements are made. The first announcements are about the individual MVPs. With 3 judges, I am very proud to say, actually, there was no clean sweep. This was a split decision. But winning the 2-1 split decision for attorney MVP from the defense, Ms. Anya Luo. There is an irreconcilably split decision for the witness MVP because there are 3 different votes. To share in this witness MVP, I've never seen this so split, but we have Kayla Hua, Charlotte Adelaide Lamb, and Vivian May. This takes us to our results. Just like there was a 2-1 split decision for the attorney, there is a 2-1 decision in this trial today. So, great job to both teams. But moving on to the final round is the defense. Congratulations to both. I'm going to make sure you get your ballots in Slack immediately. And if you want to stay on longer to speak, I understand it's quite late Hong Kong time, but if you want to, I'm sure some folks here would love to do that. Well done. Very good learning round to everybody. I'm going to stop the recording now.